This is case number 2006-0049, State of New Hampshire versus Jeffrey Pepin.
Mr. Gordon?
May it please the court, I'm Joshua Gordon. I represent the defendant, Jeffrey Pepin. Mary Pepin placed the 911 call 7 hours after the assaults that result in the convictions here. Rule 803.2 says that statements relating to a startling event made while the declarant is under the stress of the event, not after the declarant has a chance to determine what might or might not be wise to say, in this court's words in State versus Coppola. That's 7 hours of repose, 7 hours for reflection, 7 hours for evaluation of what she was going to say.
You want us to say as a matter of law that you can't do it in 7 hours? It is a matter of law?
To do what, Your Honor?
That you can't have an excited utterance 7 hours later?
Well, in the cases where there's lengthy amounts of time between the event and the utterance, the event is going on for a long time, or lapsing in and out of consciousness. She laid in bed for 7 hours, and she said her testimony is that she pondered, she thought, she planned, and that period of repose between the assault and the 911 call is such a great amount of time, and there's so much opportunity for evaluation that to allow this to be admitted just undoes the rule. The lower court used Mary Pepin's hysteria as a reason for allowing the tape, but nobody can maintain hysteria for 7 hours. And to the extent that she was hysterical, and the tape is obviously hysterical, it was caused by the escape, concern for her child, or that's just her storytelling demeanor. That's just how she tells the stories. And the solution is to expurgate the 911 tape. It's no problem with the jury hearing the portions of the tape concerning the escape or concerning the time she lay in bed, but not the assault. And I urge you to listen to the tape. It's highly prejudicial, and it's probative of absolutely nothing. It doesn't contain anything that's not in the record voluminously elsewhere.
What's its evidentiary value? Is it harmless error? I mean, I wasn't clear to me from the briefs what she said in terms of the content, or whether you could even understand her.
If it were merely the content, it would be harmless error, I agree. But you can understand the words. You pay attention, you can understand it. But the overwhelming emotion is so prejudicial that its prejudicial prejudicial effect just overwhelms any probative value. It's got no probative value. I want to turn my attention to the 404 issue. And I want to talk about Jeffrey Pepin made some threats to Mary Pepin sometime in the past. And Mary believed that he was stepping out on her. And she called the husband of the woman who he had allegedly been having an affair. And the husband called Jeffrey Pepin and said, "Don't do this, I'm going to blow your head off." And there had reason to be, it was a credible threat. He was a federally licensed gun dealer and so forth. Later on, more recently, Mary then believed the defendant here was again cheating on her. And she said she'd call the husband again. And then that's the threat here. Then that's when the defendant made a threat. He said, "If you do that, I'm going to shoot you." It was a conditional threat. The condition was never fulfilled. Mary never called the husband. To show intent, and that's the reason it was the trial judge let the 404 evidence in. To show intent, if the condition were fulfilled, if Mary had called the husband and then had hurt her, then it would show intent. But it doesn't show intent. The condition was never fulfilled. It's nothing but propensity to use violence or violent words in his marital affairs. Related to that is the 609 evidence, and that is Jeffrey pled guilty, a NOLO, to a Class B misdemeanor for that threat. It was a criminal threatening. It's not a felony. It's not a truth-telling crime. The Rule 609 flatly bars the evidence that was let in because the trial court thought there was some discrepancy between his testimony and the conviction. But there was no discrepancy. He was reluctant, for sure, to admit it, but he conceded the threat and he conceded the crime. And it's not like that case where the guy drove. It's cited in my brief, where the guy said on the stand, "I never drove a car," but he had 3 convictions for drunk driving or something like that. and application of Rule 609 would allow a perjury. It's not like that. Here, he conceded the act. And the conviction is very prejudicial because it shows the defendant coming into the courtroom was a criminal. One more issue, and I realize this is a 3JX case, but this issue is of first impression. The couple was in marriage counseling, and then the marriage counselor testified as to what happened in those sessions. Mary, nowhere on the record, waived her right, her privilege, her doctor-patient privilege, and the defendant clearly didn't waive. But even if Mary did waive, it takes two. Well, the state claims that the issue is not preserved. There was a chambers conference, excuse me, and then the judge came out of the conference and said on the record, if one side waives, it's waived for both. And the objections had obviously been made in chambers. They had a chambers conference about the issue, and the judge came out and put that decision on the record.
But there was no then contemporaneous objection made on the record by defense counsel?
There was a discussion about the entire issue. The psychologist came in with her own counsel concerned about the privilege, and the judge put on the record, there was a chambers conference.
I understand that. You're not answering my question. They talked about it, the judge decided if it was waived for one, it was waived for both, said that on the record, and then defense counsel did not say, please note our objection.
Correct. There was no contemporaneous objection.
So where's the preservation?
Well, the purpose of preservation is to give the judge an opportunity to rule, and the judge clearly had an opportunity to rule. So I think it was preserved because there was an opportunity to rule.
Thank you, Mr. Gordon.
Thank you very much.